Speaker is one of our best counsel in Canada. Mr. John Rosen probably has done as many or more murder cases than any lawyer in the country. He did us all proud in his classy handling of a very difficult case, the Bernardo case, and I think that what he has to say to you will be very important.
Thanks very much. Can you think of another profession or another line of work or just an ordinary job where you have to stand up in public and perform, not from a script, to accomplish certain ends, and particularly to argue a position to get people to believe that what you're saying is correct and what somebody else is saying is wrong, and not make a complete ass of yourself? I can't think of another profession that does that, except maybe speaking to groups of lawyers like this. And that's the job that we've chosen for ourselves. And so many of us forget that when we're in that courtroom, what we're part of is the most exciting, difficult sort of human drama that one can imagine. Somebody didn't sit back in an office or their library and write out the lines for the actors to speak and the movements across the stage and the setting and so forth. When we go into a courtroom, we are performing in public as part of this human drama that we call trial. And the object of the exercise is not to entertain, but to convince, to argue your point. And as I listened to the speakers today, and in preparation for today, I had occasion to look at Larry Posner and Roger Dodd's book, Cross-Examination Science and Techniques, which I commend to all of you, since all of our speakers have relied heavily on it. But they make that point, and they make it well, that in fact no case is won by the opening, and no case is won by the closing. It is won, if at all, by the cross-examination, because the cross-examination is the argument. And like every good argument, you need a good opening and you need a great closing, especially the cross-examinations that count. And that is, in my opinion, one of the most difficult things to accomplish in any trial. I've seen counsel spend hundreds of hours preparing by reading the material, by analyzing it, by trying to identify the issues, trying to work out a game plan. And they finally get to court and they're all ready to go. And we've picked the jury, they're all assembled, they brought in the accused, you're sitting behind your counsel table, you're dressed in your best black, and the prosecutor stands up, makes a terrific opening about a damning opening about your client and this heinous crime that's alleged to have been committed by him or her. They call the first witness, and most often than not, the complainant, the victim, the mother of the deceased, somebody who will draw the attention because they have the opening. And they do this examination in chief in an important case where they've prepped that witness for months. Interviews, discussions, read the evidence, cross-reference it, prepare for the anticipated cross, and they've prepped them. And everybody watches this, and then that moment of truth comes, and the judge turns to you and says, Mr. So-and-so or Mrs. So-and-so, would you cross-examine the witness? Years ago, I did a trial, a fraud trial, 3 accused, 2 brothers and their cousin. The cousin was first on the indictment. I represented the 2 brothers. I shouldn't have, I guess. We should have had separate counsel, but I did. And my position was that this fraud that's alleged to have happened, if it happened at all, the cousin was the mouthpiece, and he did it all. And we're just like sort of dragged along, minor investors, kept our mouths shut, and we were hiding in the weeds in this trial. The first complainant gets in the stand, does a terrific job. Doug Hunt was the Crown. Did a fabulous job in front of the jury. My co-counsel stood up, and he started to shuffle his papers together. All eyes in the courtroom are watching him. And he leans over to me and he says, "Will you go first?" At that moment in my heart, I knew we lost. And it got worse, if you can believe it. He walked over to the podium, put his notes down, shuffled them for a while, walked over to where the clerk was, asked for a few exhibits, dropped a couple on the floor, picked them up, walked back to the podium, checked his notes, walked back to the registrar, gave some exhibits back, took some other ones, came back to the podium, looked at the witness, looked at the jury, and started in the middle of the story. The opening line was, I can't remember what it was, but I thought, where the hell is he going? What's he talking about? I didn't understand it, and I was counsel in the case. Can you imagine these jurors? They don't know where you're going, what you're doing, why you're doing it, and what point you're trying to accomplish. And that's the importance of an opening. Mike Edelson made the point so succinctly when he said, if the issue is reasonable and probable grounds, the first question out of your mouth in the circumstances of that case is, "Officer, are you a reasonable man?" I mean, it's just so simple, and yet it's such a good opening. And it sets up the closing in your cross-examination, which is, in essence, a mini jury address or a mini argument. I suppose for me, the highlight of my career came after I had cross-examined Carla Homolka, and some members of the press came to me and they said, "We should tell you what was going on in the courtroom." I said, "What was that?" And they said, "Well, we were taking bets. As court watchers, we were betting on which line you would use to open your cross-examination. Would it be, 'Now, Ms. Homolka, would you agree with me that,' as you hear so many people do? Would it begin by, 'Now, Ms. Homolka, you did plead guilty to killing your sister and killing, the other two, got off with the manslaughter.'" And they went down the whole litany of the standard openings. And they said they all lost their bet and they should give me the money because I fooled them all. And I can tell you that the opening in that case, of that cross-examination, took me months of thinking about it, almost from the day I started the case. I knew that one day soon I would be standing in a courtroom looking at my audience, not the judge, not the court reporter, not the clerk, not the 200 people behind me, not even the boy in the box, but the 12 people who I thought initially were going to come over the rails and send me away with him. But they're my audience. And I'm thinking to myself, now, how do I get my point across? And I thought about it, and I thought about it, and I still really didn't have an answer until she started to do her examination in chief. And what was presented was a witness who was a killer as much as anyone, and who was being presented by the prosecution as a victim. And I watched that jury squirm, and they just didn't feel right about it. Yes, it was terrible. They watched her. They didn't like her, but they didn't know why they didn't like her, besides all the superficial stuff. There's something about it. I mean, they're supposed to be buying her evidence, and it was sort of that moment of truth. And the prosecution had forgotten why we were there. And so I had to remind the jury why. And I stood up and I said, "Who's this picture?" "That's my sister Tammy." "Alive, right?" "Yes." "And this picture?" "Well, that's Tammy too." "Dead on a gurney, isn't it?" "Yes." "And who's this picture?" Leslie Mahaffey. "At her graduation, right?" "And who's this? Or what is this?" Well, pieces of Leslie Mahaffey's body encased in concrete. And this girl, well, that's Kristen French. And this nude body on the side of a road, well, that's her dead. And that's what we're here about, isn't it, Miss Homolka? Yes. And that got everyone's attention, and it shook her up. Now that's openings. Simple openings give the best results. You may have a witness with a criminal record, and you begin, as I did years ago, and you say, now witness, would you agree with me that you are a thief? You have no respect for the administration of justice, and ultimately you are a liar. Well, no, you know. Well, well, no to which, you know. Well, let's see what your record says. And you go to the record. And that's where you have to have one of those head-on confrontations. Now, the problem with a good opening is that it only has to be good. It shouldn't be great. Because if it's a great opening, you got no closing. The purpose of the opening is to get to the closing. The standard Crown cross-examination in a tough case with the accused, for example, would be, you know, whittle away, whittle away, whittle away. And finally, you see the great flourish. And I suggest to you, sir, that you are the killer in this case. Isn't that right? And as a client of mine so eloquently put to the prosecutor, and he was given his background and so forth, he said, and I suggest to you, Mr. So-and-so, that you're full of shit. And not knowing what to do, the prosecutor sat down. And the accused was acquitted. So you have to be very careful. And the best way, I find, to close with a witness is always try and close on a high point. Open with your best shot, but save something for the closing. Often it is an inconsistency in a statement or a transcript, or it is a series of inconsistencies, or it is, as Graham Reynolds pointed out, so just so I understand the point here, 1, 2, 3, 4, 5, thank you very much, and sit down. The conclusion. And every once in a while, you get lucky. You get a piece of evidence, such as a statement or a videotape now. I love videotapes. And you take that segment that's so important, and you remember who your jury is, and you beat up on the witness, and then you get to the point, and then you talk to the jury. Let me give you an example. 3 accused stand trial in a home invasion type robbery. The theory of the defense, anyways, was that the lead accused went to this home to save the princess and get the jewels, and at least that's what he told his cohorts, and they all went in and they beat up a 13-year-old, tied her up in a cupboard, and they waited for the princess to come home with the guy who was supposedly holding her captive, and he came home alone. And these guys all jumped him, and they hit him with a bottle of soy sauce and a whole bunch of stuff, and there's blood and everything, and he's down. But that wasn't good enough, because somebody tried to tape his wrists together, and somebody ultimately handcuffed him, and then he was dragged into a bedroom where the number 1 accused, because of his passion and so forth for the love interest, took another bottle of soy sauce and beat the guy's head to a pulp with blood everywhere. Now, I acted for the number 1 helper, and the problem that I faced was that, yes, we were there, and yes, we participated in the initial assault. We were there for a different purpose, not for murder, but we got stuck with Harbottle, because if we're putting on the cuffs or taping the wrists or in some way putting him down, then we're causing death and participating in a murder causing death, and we're going to be dinged for first degree. So how to extricate ourselves from that? Now, one of the bandits becomes a Crown witness. And he's the first one actually to be caught out in Vancouver. And the boys in blue fly out to Vancouver and they interview him on video. And in the course of the video, they ask him what happened. He tells the story. And he goes all the way through the story and doesn't mention anything about the handcuffs or the tape. So they ask him, well, did you ever see a pair of handcuffs? And he says, yeah. He says, I think somebody had handcuffs, but I don't remember who it was, and I didn't see if they were used or not. Well, what about tape? Did you see somebody taping the wrists of the deceased? And he says, yeah, I somehow remember somebody taping, but I just can't remember who it was, as he circles his hand on the video. And later on, when he got to trial, he suddenly remembered that it was my client who put the tape on the hands. So, I mean, I had to do this. I had to get rid of that evidence. And the theme that I developed was that he was the one who was standing where he put my client, and he was the one who had the tape, and he was the one who circled the hands. And the last thing the jury saw when I finished my cross-examination was the clip of the tape where he was circling his hands, and I said thank you and sat down. And the end result was the number one accused was convicted of murder, and the other two helpers who were on trial were only convicted of manslaughter. So, ladies and gentlemen, when you are doing your cross-examination, whether it's in a little assault case, whether it's in a major murder case, or for that matter, a boring fraud case, or a tax evasion, or whatever it is, and whether it's a little cross, a cross for information, a cross for credit, a cross where you have to call the witness a liar, think of it as an argument with a beginning, a middle, and an end. Think of your opening to catch the attention, announce the theme, and announce where you're going, and think of the end as your punchline for when to sit down. And now it's my turn to sit down. Thank you.